I'll now turn to the issue which is generating a bit of some controversy here, presidential immunity. I'm the one, through my petition in the High Court, E426 of 2020, who brought or dragged the president to court. And I asked for the orders that I asked for, based on Article 143, not exactly what I asked for. I simply said that you can institute civil proceedings against a president for actions that he undertakes or omissions outside his functions of office. In other words, Article 143, Clause 2 protects him, gives him immunity when he's performing the functions of office as president, functions of presidential office. And I basically said, when he was busy setting out Kenya Gazette notices, establishing the BBI authorizes him to engage himself in constitutional change matters outside Article 256. Yes, Article 143, Clause 2 did not prohibit us from instituting an action against him. And that is basically what I had asked for. Contrary to the Constitution, the pronouncement of the court was wider than what I had asked for. I had confined myself to conduct outside his functions of office. But if you apply what the High Court said, you can sue him for anything that he does that is unconstitutional. Unconstitutional includes both functions within his office and functions outside his office. And that is a bit that I disagree with. And I'm saying that particular order was wider than my prayer. I'm urging this court to revert to my prayer and not go beyond my prayer to what the court, High Court, and as affirmed by the Court of Appeal, went. I'll give an example. If I use the pronouncement of the High Court and the Court of Appeal as law, and if I am Justice Joel Ngugi or Justice George Odunga, who are involved in this matter at the High Court, because they ruled in the manner that they did, and the president doesn't like them because they scuppered reggae or they messed up BBI, his pet project, when other judges were being promoted to the Court of Appeal, they were left out. I mean, for us Kenyan citizens speculating, we say the only reason why they were left out was not because of their inability to act as judges, but it was simply because they came up to a determination that messed up the president's plans. Now, if I rely on that particular order from the High Court and the Court of Appeal, Justices Ngugi and Odunga can actually go ahead and sue the president right now, maybe in the Employment and Labor Relations Court, for the deficit in their remuneration compared to what they're earning now as High Court judges, compared to what they should be earning as Court of Appeal judges. And of course, they would have a case, because that particular order allows them to do that. The president acted unconstitutionally, violating Article 166, because once he has received a recommendation from the Judicial Service Commission, he's supposed to ceremonially appoint all those judges to office. He didn't do that. But I'm saying, no, Justices Ngugi and Odunga cannot sue the president, even in such circumstances, because appointment of judges is a function of presidential office. And Article 143, Clause 2, gives him immunity from being sued when he's performing a function of presidential office. Yes, he conducted himself unconstitutionally. Nevertheless, he has that defense in Article 143, Clause 2, and therefore the two justices have to wait until he's no longer in office. And that is where Article 143, Clause 3 comes in, limitation of time. I know it's been raised by the AG, it's been raised by the president's team, trying to misconstrue Article 143, Clause 2. No, it was there precisely to protect the rights of such persons, such as Ngugi and Odunga. If they decide once Uhuru is no longer in office that they want to sue him, they can, but they have to wait. They can't do it now. And that is why Article 143, Clause 3 is there. That same Article 143, Clause 3 can also apply to minor traffic offenses. For example, if you look at Section 50 of the Traffic Act, if somebody has committed a traffic offense, the person intending to prosecute you has to inform you within a particular defined period, 14 days or so, or send you a notice to your last postal address and things like that. Now, we know every once in a while we see President Uhuru driving vehicles and everything else. He could commit a minor traffic offense just like anybody else. But because that particular criminal offense or traffic offense, as the case may be, does not fall under Article 143, Clause 4, 1E. Article 143 protects the rights of the DPP to bring any prosecution against the president, AG. The president does not have to get some clarification here. Article 143, Clause 3, sorry, Article 143, Clause 2 gives him immunity against civil proceedings being instituted against him. It doesn't talk about immunity against constitutional proceedings. It doesn't talk about immunity against electoral proceedings. After all, we have presidential election petitions. The president is sued. He was sued by Raila Odinga in the last presidential election petition. And that was valid and it was admitted before the court and the matter was dealt with. In other words, we are only talking about civil matters. Constitutional matters can be brought against the president. Electoral matters can be brought against the president in his own name. So when we hear the president's team trying to argue for blanket, absolute immunity on grounds outside the Constitution, you must not allow yourself to be misled on that particular path they're trying to lead us. In fact, they're calling upon the case, the Bellevue development case. It was decided, well, at least the lead judgment in the Court of Appeal was by Patrick Kiage. I've read through the case, and I believe that was a simple case of judicial overreach. Judges could be accused of basically protecting themselves and using their position, their office, to protect themselves as opposed to stick to the letter and spirit of the Constitution. If we, the people, in the exercise of our sovereignty, says you can't sue a judge except if they act unlawfully or not in good faith, we knew exactly what we're talking about. We cannot have a judge come and say, no, judges are superhuman. They're super righteous. I mean, you can't have a judge doing anything unlawfully or out of good faith. So therefore, I'm going to ignore those particular phrases, those qualifications. Unlawful, without good faith, that's out of order. That judgment was wrong. And when it came to the Supreme Court should have shut it out, but it did not. And I think even the Supreme Court was wrong. But then, as I said at the very beginning, you are not bound by the decisions of anybody, not even your own decisions. Therefore, don't allow yourself to be bound by that wrong decision which you affirmed, which came from the High Court. The letter of the Constitution in terms of judicial immunity is exactly as we put it. If you act unlawfully, if you act without good faith, you can be sued. I know the lower courts wouldn't do anything different to what you've said because they're bound by your orders. But now we're calling upon you to do the right thing. Be faithful to the Constitution. The sovereignty we delegated to you was only in accordance with this Constitution, not beyond this Constitution, not by the exercise of judicial overreach or any other judicial games people play. No. Just like we're supposed to be faithful, you too are supposed to be faithful to that particular Constitution. And therefore, the Bellevue decision case is wrong. Depart from it and do the right thing. Because right now the president is saying, well, judges, you gave yourselves absolute judicial immunity. The Constitution did not, but you gave yourself absolute judicial immunity. Come on, do me a favor too. Give me, the president, also the same judicial absolute immunity that you gave yourselves. That is basically what the president's team is asking over here. We cannot have that. No. Who is boss in this country, I asked earlier on. Is it Martha Koome? Is it Uhuru Kenyatta? Is it Devin D? Or is it us, the people? Who is boss? If we, the people, are boss, then our word should rule and prevail. And if we put qualifiers in judicial immunity, like unlawful, not in good faith, we mean exactly what we say when you put those particular phrases in the Constitution. They're not to be ignored by judges. You're supposed to act faithfully in upholding that Constitution. That is the delegated authority we gave you, not to act beyond the authority we gave you. So Bellevue decision is wrong. Uhuru Kenyatta as president cannot rely on that in an effort to get himself absolute immunity. He does not have absolute immunity.